We'll now hear oral evidence from Eduardo Usteran, the Global Co-Head of Privacy and Cybersecurity Practice at Hogan Lovells, who's appearing via Zoom, Vivian Arts, OBE, who's joining us in the room, and Bojana Bellamy, President at the Centre for Policy Leadership, who's also appearing via Zoom. For this session, we have until 10:25. Could I ask, please, the witnesses to introduce themselves for the record, starting in the room with Vivian Arts.
Good morning, my name is Vivian Arts. I'm the chair of the IRSG Data Committee. I have over 25 years experience in financial services, including acting as a chief privacy officer, and I now do advisory work across a range of sectors, including in the context of financial crime.
Could I ask Eduardo Usteran to introduce himself, please? Can he hear us, Mr. Usteran? No. Bojana Bellamy, can you hear us, Bojana? Okay, so what we're going to do is we're going to start with our witness in the room, who's been kind enough to join us, Stephanie Peacock.
Thank you, lovely. My first question to Julie is, would you be in favour of implementing a smart data regime in your industry, and if so, why?
Yes, I think we're interested in implementing a smart data regime because it will allow broader access to data for innovation, particularly in the context of open banking and open finance. It does require access to information which at the moment can often be limited, and there's a lot of concern from businesses around whether or not they can actually access data. Providing some clarification about what that means, information which is not necessarily sensitive, which can be used for the public good, would be most welcome. At the moment, the provisions in the legislation are pretty broad, so it's difficult to see what that's going to look like, but in theory, absolutely.
Okay, and who, in a bit more detail, would you think would benefit or lose out, and in what ways?
I think consumers would absolutely benefit, and I think that's where our priority needs to be, is with individuals. It's the opportunity for them to be able to leverage the opportunities that the data can provide. It will enable innovators to produce more products and services that will help individuals better understand their financial circumstances, their personal circumstances, particularly in the context of utility bills and so on. I think there are a number of very positive use cases. Obviously, there's always the opportunity that data can be misused, but I'm a great advocate of saying that we need to find those positive use cases and allow business to support society and our consumers to their fullest. And so that's what we need to support.
That's brilliant. And what are your thoughts on giving the power to the Secretary of State to amend data protection legislation further? And do you think it's necessary to future-proof the bill?
I think it is necessary to future-proof the bill. We're seeing such an incredible speed of innovation and change, particularly with regard to generative AI. We do need to make sure that the legislation remains technology neutral and can keep up to date with the changes that are currently taking place.
Okay, that's great. Thank you. I've got some, if our other witnesses are with us. If not...
We still haven't heard definitively if our other guests can hear us or speak to us, so we're going to wait for confirmation from the tech people. In the meantime, I'm going to ask the Minister if he has any questions for Vivian Arts.
Thank you, John. Can I ask you, you have a lot of experience around international data transfers. Obviously, the European Union has a number of data adequacy agreements around the world, but it has been a slow process, I think, in establishing those. Can you say how you think the bill will make it easier for us to improve international data agreements and what prospects you think there are for the UK to establish such agreements with which countries?
I think what the bill has provided for is the opportunity for government to look at a range of issues, so to move away from an equivalent approach to one where we can consider more factors and features. The reality is that if you compare two pieces of legislation, you will always find differences because they come from different cultural backgrounds, they come from different legal regimes. There will always be differences. I think the UK approach that they're taking under the bill is very helpful because it looks at outcomes It looks at broader issues like the rule of law in different jurisdictions, because what is said on paper isn't necessarily what always happens in practice, and we actually need to look at it far more holistically. And I think the legislation gives government the opportunity to take that broader and more common sense view with regard to adequacy, and not just do a word-by-word comparison of legislative provisions without actually looking at, but how is that implemented in that jurisdiction? What other rights can support the outcomes, recognizing that it's a different legal process and application, but does it still achieve the same end? And that's what's really important. So I think that there's an opportunity to move more quickly in this space, but also to consider jurisdictions which otherwise might not be immediately obvious, but nonetheless still offer appropriate safeguards for data.
And obviously it's already possible for us to undertake international data transfers to countries where we don't have an adequacy agreement. Can you just set out what the advantages are of being able to have a general adequacy agreement in terms of data transfer and the benefits to the UK economy?
The current process is incredibly cumbersome. It's cumbersome for businesses, and it provides zero transparency, if I'm honest, for individuals as well. It tends to be mostly a paperwork exercise, which forgive me if that sounds provocative, but putting in place the model clauses is very often an expensive paperwork exercise. And so at the moment it is difficult, time-consuming, costly, as the case may be. The thing with adequacy is that it's achieved at a government-to-government level. It's across all sectors. It provides certainty, and organizations can move forward to share information, to sell their goods and services elsewhere, to receive those goods and services, and for consumers to access those opportunities as well. Adequacy is certainly the ideal. Whether or not it's achievable in all jurisdictions, I don't think so, but I think it is achievable for many jurisdictions to provide confidence for both consumers and businesses on how they can operate.
Thank you.
Okay, are we now joined by Mr. Duran and Ms. Bellamy? Can you hear me? Can you nod your head if you can hear me? Right, we can see them, they can hear us, but we can't hear them. So we're going to carry on with questioning Vivian Arts. Karen Monaghan.
Thank you. A number of organisations have raised concerns about moving to a situation where we can refuse requests, subject access requests, or indeed charge a fee. Do you believe that the thresholds in the bill are appropriate and proportionate?
I do think that the thresholds are appropriate and proportionate. In practice, most organisations don't actually choose to charge because actually it costs more to process the cheque than it's worth in terms of the revenue. Certainly for some sectors, they've been subject to very vexatious approaches through claims management companies and others, where it's a bombarding exercise and it's unclear actually whether it's in the best interest of or at the understanding and behest of the actual consumer as to whether or not they're making a genuine subject access request. I'm a great supporter of subject access requests. It's a way for individuals to exercise their rights to understand what data is being processed. But I think as a result of quirks of how we operate often in the UK, it's been used as a pre-litigation investigative tool on the cheap, which is unfortunate and has meant that we've had to put in place, I suggest, additional safeguards to make sure that subject access requests are used for the purpose for which they were provided, which is so that individuals can have transparency and clarity around what data is being processed and by whom.
Do you think it's well understood what the threshold would be for something to be considered vexatious or excessive?
I think we've heard from the Information Commissioner that they are fairly clear on what that terminology means, and it will reflect the existing body of law and practice. I'll be perfectly honest, it's not immediately clear to me, but there is certainly a boundary within which that could be determined, and I think that's something that we rely on the Information Commissioner to provide further guidance on. It's probably also likely to be contextual.
And how frequently do you expect such requests to be refused off the back of this?
I think it depends on the sector. I come from the financial services sector, so the types of subject access requests we get tend to be specific to us. I think that organisations are going to be reluctant to refuse a subject access request because at the end of the day, an individual can always escalate to the Information Commissioner if they feel that they've been unfairly treated. And I think organisations understand their responsibility to act in the best interest of the individual at all times.
Thank you.
Ms. Bellamy, can you hear us? Right, well, we can't hear you. Mr. Usteran, can you hear us?
Usteran here.
I can't hear you, Eduardo.
Well, we can now in the room.
Can you hear us now?
We can now hear both of you in the room.
Excellent,
So-
wonderful.
Okay.
Ms.
Can you
Bellamy,
hear me? This is Eduardo Usteran here.
Thank you.
Can you hear me?
Yes, we can. Can you hear us?
Absolutely.
Right, Ms. Bellamy, would you be kind enough, please, to introduce yourself?
Thank you very much, and thank you indeed for inviting me for this hearing. My name is Bojana Bellamy. I lead Center for Information Policy Leadership. We are a global data privacy and data policy think and do tank operating out of London, Brussels and Washington, and I've been in this world of data privacy for almost 30 years.
Thank you. Mr. Usteran, would you be kind enough to introduce yourself?
Good morning. My name is Eduardo Usteran. I'm a partner at Hogan Lobos, based in London, and I co-lead our global privacy and cybersecurity practice, so a team of over 100 lawyers specializing in data protection law all over the world.
Lovely, thank you. Chion Wara and Damien Collins are lined up to ask questions, but I want to ask the Shadow Minister first of all if she has any further questions, followed by the Minister. Because we've now got one witness in the room and two online, whoever's asking the question, please will you indicate who you're asking the question of? Stephanie Peacock.
Thank you, Chair. Good morning to our guests joining us via Zoom. Firstly, to Ms. Bellamy, in your opinion, has it been difficult for businesses to adapt to the EU GDPR? And if so, do you think the changes in this bill will make it easier or harder for businesses to comply with data protection legislation?
Thank you. Yes, certainly I think it has been hard to get businesses to comply with GDPR, in particular small and medium-sized businesses. I actually think that the changes that we are seeing proposed in the bill are going to make it easier. And why do I say that? Because it is actually more about outcomes-based regulation. It's more about being effective on the ground as opposed to being prescriptive. GDPR is quite prescriptive, quite detailed. It tells you how to do things. In this new world of digital, that's not very helpful because technology always goes in front and faster than the rules. So in fact, what we are seeing in the bill, proposed bill, is more flexibility, more onus on organizations, both public and private sector, to deliver accountability and effective protection for people. But it doesn't tell them and prescribe how exactly to do that. Yet they're still accountable for the outcome. So from that perspective, I think it will be, it is a step forward. It's a better regime, in my opinion.
Thank you. And to Mr. Usteran, what do you perceive the value of EU adequacy to be? What would be the consequences for your businesses and other businesses and the UK markets of losing such an agreement?
From the point of view of adequacy, I think it is fundamental to acknowledge that the value of data flows between the UK and the EU and the EU and the UK is essential for global commerce and for our digital existence. Therefore, adequacy is an extremely valuable element of the way in which the current data protection regime works across both the EU and the UK. I think it's really important to note at the outset that the changes that are being proposed to the UK framework are extremely unlikely to affect that adequacy determination by the EU in the same way that if the EU were to make the same changes to the EU GDPR, the UK would be very unlikely to change the adequacy determination of the EU. It's important to appreciate that these changes do not affect the essence of UK data protection law. and therefore the adequacy that is based on that essence would not be affected.
Thank you. Well, you've answered my next question, but if I pose it, then perhaps the other witnesses may have something to add. I mean, in the previous session, the Information Commissioner has said that he didn't think this bill was a threat to adequacy. I think that's comforting, but it's not confirmation, is it? Because the only people who have the power to decide whether adequacy stands is the EU Commission. So my sort of final question, which I think you've touched on, Mr. Osteran, but if either of the other witnesses want to come in, is do you think any of the measures in this bill pose a risk to the adequacy agreement? So, Ms. Bellamy, if you wanted to, then.
Yes, thank you very much. I certainly would agree that adequacy is a political decision, and I think in many ways, and you have seen that with Northern Ireland Protocol, you have seen that some of these decisions are made for different purposes. I do not believe that there are elements of the bill which would reduce adequacy. If anything, the bill is very well balanced. Let me give you examples where I think the bill goes beyond GDPR, certainly on requirements of expectations of accountability, on the senior responsible individual, which actually delivers better oversight and leadership over privacy, the right to complain to organizations and for organizations to respond to these complaints, the strong and effective information commissioner that has got actually more powers. It's more smarter regulator. That again is a better, I think, than GDPR. The safeguards that exist for research and scientific research and similar purposes and some other detailed ones. Yes, I think you will see, and you've seen that in public project as well, there are people who are worried about the erosion of the rights, but I do not believe that exception to subject access requests and other rights that we talked about is actually real erosion. I think it just clarifies what has been the law. Some of the requirements to simplify privacy impact assessment, records of processing, in fact, they will deliver better accountability in practice. They're still there, they're just not as prescriptive. The Information Commissioner has got strong powers, it's a robust regulator. I don't believe that their independence is going to be dented by this bill. So I actually say to those who think that we are reducing level of protection, I would say actually the balance of all the rules is going to be essential equivalency to the EU. So I think that's really what's important. May I very quickly also say one thing. We have seen EU make adequacy decisions in countries regarding countries such as Japan, Korea, and even Privacy Shield. And even in these cases, you have not had a situation where the requirements were essentially equivalent. So these laws are still different from GDPR. They don't have right of portability. They don't have concept of automated decision making, but they're still found to be adequate. So that's why I really do not believe that this is a threat. One thing that we have to keep absolutely clear and have to keep on par with the EU is the government access to data for national security and intelligence purposes. This is something that EU is going to be very interested to make sure that that's not where the bar goes down. But there is no reason to believe so, and there's nothing in the bill to tell us so.
I would concur that I don't think that the bill poses any threat to adequacy with the EU. With regard to the national security issue which Bojana raises, I would also point out that the UN rapporteur noted that the UK has better protections for government access to data than many EU member states. So, you know, I think that's often a very political approach as opposed to a practical approach and really looking at what the outcomes are. But there's nothing that in this bill I feel that would jeopardize adequacy with the EU.
We've got 12 minutes left. Minister, after you, there are two other members indicating they wish to ask questions. Minister.
Thank you. Mine will be very quick. You've suggested that in some ways what the regime that the bill puts in place is superior to that of the existing GDPR regulations, and certainly that in your view it doesn't in any way risk our adequacy recognition. I wonder, given the development of technology and the increasing use of things like AI, to what extent do you think the EU may actually follow down the same sort of path that this bill sets out to try and create a more flexible and state-of-the-art regime?
Who's that directed at, Minister?
I think, well, any of the witnesses you want, but particularly perhaps Ms. Bellamy, who
Mr.
Starring as well.
Ms. Bellamy.
Thank you very much. That is a very important question to address, because perhaps one of the ways in which we should be looking at this legislative reform is a way of seeing how the existing GDPR framework, which exists both in the EU and the UK, could in fact be made more effective, more relevant, and more modern to deal with the issues that we are facing right now. You refer to artificial intelligence being one. And if we look at the GDPR, both in the EU and the UK, it's about 5 years old. It's not a very old piece of legislation, but at the same time, a number of things have happened from a technological development point of view in the past 5 years. And more important than that, we have learned how the GDPR operates in practice. And therefore, this exercise that we're seeing in the UK is in fact a very, very useful exercise, not just for the UK, but for the EU and the world at large, because it's looking at how to reform elements of the existing law that are already in operation in order to make them more effective. That doesn't mean that the law needs to be more onerous, or it doesn't mean that the law needs to be stricter, but it can be more effective at the same time that it is more pragmatic. So then, this is an important optic in terms of how we look at the legislative reform, and not only that from the point of view of the UK, but I think the UK can make an effort here to try to make these changes more visible outside the United Kingdom, and in fact possibly influence the way in which the EU GDPR evolves in the years to come.
Ms. Bellamy.
Yes, I would certainly agree with the fact that we do need a bit more flexible legal regime to enable responsible use of AI and machine learning technologies. To be very frank with you, I was hoping the bill would go a little bit further to that extent. I was hoping that there would be, for example, a recognition that use of data in order to train algorithms to ensure non-discrimination, non-bias algorithms, to ensure they function properly. I would have hoped that would be considered as an example of legitimate interest. And certainly that is the way the government can go in further, because there are possibilities for the Secretary of State to augment these provisions. If anything, we have seen that in the European AI Act, where they are now allowing, if you like, greater use of data for algorithmic AI training in order to precisely ensure that they work properly. We've got Dubai, data protection law, and some others starting to do that. So I would hope this is the, we have got good foundations to ensure further progression, if you like, of the rules on AI. But certainly I would say the rules on automated decision-making are better, in my opinion, in this bill than they are in GDPR. They're more realistic. They understand the fact that we are going to be faced by AI and machine learning more and more taking these decisions, of course, with the possibility of human intervention. And again, to those who criticize the rules, I would say, I believe it's more important to have these ex post rights of individuals emphasized the way we have done it in the bill, the right to information, that there is AI involved, the right to make a representation, the right to contest the decision, the right to demand human review or human intervention. This, to me, is really what empowers individuals and gives them trust that these decisions will be made in a better way. There's no point prohibiting AI the way that it is sort of in GDPR. And you see in GDPR we're going to have this clash somewhat between the fact that the world is moving towards greater use of AI, yet we have got in automated decision-making, Article 22 GDPR, this prohibition which makes it subject to consent or contract. But that's really unrealistic. So I think we've again chosen a better way. And maybe the third small detail, I find the rules on research purposes to be smarter, rather complicated to read, to be very frank, but you know, I look forward to the consolidated, clean version. But the fact that the commercial research, technological development research is included here would actually enable those organizations that are developing AI to create these rules in a way that is responsible, that creates right outcomes for the people, does not create harms and risks. To me, that is what matters. That is more important. And that is what is going to be, I think, delivered here as well. And we've got, of course, the exemptions from notices for the research, etc. So I kind of feel we will have better conditions for development of AI in a responsible and trusted way. But we must not take our eye off it. We really need to link GDPR with our AI strategy, and we need to make sure that indeed we incentivize organizations to be accountable and responsible when they are developing and deploying AI. And that will be the part of the ICO's role as well.
5 minutes left. This is going to be the quick fire round. I've got 2 members indicating they wish to ask questions. Chion Wara.
Thank you very much, Mr. Oliver. So we've heard the intent of the bill is to part to reduce the burden on organisations from data protection, and we've heard you've set out how some of those burdens might be. The organisations impacted by this bill and the organisations with which you work in different ways operate in different jurisdictions, and I think, Ms. Arts, you set out quite well the challenges of having the same regime, or trying to have the same regime in different jurisdictions. So if forced to make a choice between following the European Union regime and following a divergent UK regime, what would the organisations with what choice would the organisations with which you work make?
Please choose one witness.
Well, Mr. is raising so, but I'll also Mr. Usteran.
Mr. Usteran.
Thank you very much. This is a question that, in fact, many organizations which operate globally are facing right now. You have to understand that data protection law operates all over the world, and data flows all over the world. So consistency is really important in order to achieve compliance in an effective way. Therefore, a question that is a very valid question is, do I comply with the EU GDPR across the board, including in the UK, or should I make a difference? And the reality is that when you look at the way in which the UK data protection framework is being amended, it does provide a baseline for compliance with both the UK and the EU regime, in the sense that much of what is being introduced could potentially be interpreted as already being the case in the EU, if you apply perhaps a more progressive interpretation of EU law. Therefore, I think we should look at just a little bit farther than just saying, well, if I comply with EU law, will I be all right in the UK? Maybe the way to look at it, and I think something that I can see some organizations are exploring, is if I were to take the UK interpretation of the GDPR on a wholesale basis, would that allow me to operate across the world, and certainly in the EU, in a more effective, in a more efficient, but still compliant way? So then, this is something that companies are going to be exploring, and it's not as easy as simply saying, well, I'll just do EU law across the board.
Right, I'm sorry, Damien Collins, it's got to be one quick question, one quick answer. We have to finish at 10:25. Damien Collins.
One of the complaints about the current GDPR regime has been, for example, that oligarchs use it aggressively to target investigators, journalists who are doing legitimate investigations into their business activities, to bombard them with data access requests. Do you think the provisions in the bill around vexatious requests will help in that situation? Do you think it will make any difference?
I think it'll help a little bit in terms of the threshold of vexatious, but I think the other piece that's going to help is the broadening of the provisions around legitimate interest, because now there is an explicit legitimate interest for fraud detection and prevention. At the moment it's articulated mostly as to prevent crime. I would suggest it could be broadened in the context of financial crime, which is anti-money laundering, sanctions screening and related activities, so that firms can actually process data in that way. But those are two different things. The one is processing data around sanctioned individuals and such like, and in the context of suspicious activities, and the other one is the right of a subject access to remove their data. But even if they make that subject access request, the ability to now balance it against broader obligations where there is a legitimate interest is incredibly helpful.
Thank you.
Can I thank all three witnesses for your time this morning and for your extremely informative answers to the questions.